Hello everyone, this is Tom Fox and I'd like to welcome you to episode 278 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technological firm that helps clients manage risk across 4 key risk areas. These risk areas include sales and sales channels, including distributors, resellers, and partners, suppliers, customers, and human capital, which consists of employees and contractors. You can check out more information on the Red Flag Group at their website, www.redflaggroup.com. I'm also pleased to announce another in the Red Flag Group continuing webinars on supply chain risk management. It will be on gathering information from suppliers. It will be September 15th at 10 a.m. Central. You can register and get more information on this webinar at the Red Flag Group website. Click on webinars. In today's podcast, I take a look at the issue of hiring of family members under the FCPA. Matthew Stevenson on the Global Anti-Corruption blog wrote a very interesting piece on how you should think through the 3 parts or 3 questions you should ask when hiring any family member of a foreign government official. The episode comes in at just over 21 minutes. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report. Hello everyone, this is Tom Fox. I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today I want to look at the questions surrounding the hiring of family members and the FCPA. Matthew Stevenson over at the Global Anti-Corruption blog wrote a very interesting and useful piece earlier this week entitled, "Does an FCPA violation require a quid pro quo? Further developments in the JPMorgans sons and daughters case." And in this blog post, he reviewed the facts of the case and came up with a case-by-case analysis, which I thought was just excellent, which would allow the compliance practitioner to consider or at least to begin an analysis of the individual hiring your company may go to. So let me just quote directly from Professor Stevenson's blog post. "A case-by-case analysis is appropriate here and may distinguish thumb-on-scale preferential hiring from gross attempts to offer jobs to relatives as inducements to public officials. The 3 considerations to my mind ought to be, number 1, the degree of connection between the job offer and a particular official decision or set of decisions as distinct from general goodwill and connections. Number 2, the degree to which the official indicated that he hoped the firm would hire the relative even if there was not enough evidence of an agreement to establish a quid pro quo. And number 3, the degree to which the firm relaxed its ordinary standards to hire the official's relative. On this last point, we can distinguish the nice business meal from the luxury all-paid expense vacation and the cab fare from the private jet. So too, we can distinguish between the hiring of a well-qualified candidate whose personal family connections might have been a plus factor from the hiring of a lazy and incompetent relative whose only benefit to the firm is favorable treatment by a powerful relative." All of this came about because the Wall Street Journal posted an article that talked about the JPMorgan sons and daughters hiring case in China. And at least the journal thought that JPMorgan may be moving towards a resolution of this case and had reserved approximately $200 million for a settlement. This case has been ongoing for some time and has been reported in the press. And I thought it would be a good time to take a look at this case because we had some very unusual and unique aspects. First and foremost was that JPMorgan, recognizing the high-risk nature of hiring a foreign government official's family member, a son or a daughter or a nephew, put together a hiring program literally called Sons and Daughters. And somehow in the last decade, in the 07, 08, 09 timeframe, this risk management program morphed into a program which allegedly targeted the sons and daughters of high Chinese government officials and those involved in state-owned enterprises for hiring to influence those officials' decisions to send send work and business to JPMorgan. So, for instance, in a Bloomberg article entitled JPMorgan Bribe Said to Expand in Asia as Spreadsheet is Found, it reported that, or Don Kopecky reported that there was an internal spreadsheet at JPMorgan that linked appointments of sons and daughters to the company to specific deals being pursued by the bank. And this spreadsheet is something that really ties, in many's mind, the hiring of a son or daughter or family member directly to a foreign government official and a benefit for a foreign government official. The hiring program further had a special interview / application evaluation track, which was created, one for regular applicants and one for the children of Chinese officials. And this allowed for fewer job interviews, relaxed hiring standards, and candidates who had subpar academic records and lacked relevant experience. So JPMorgan was clearly targeting, at least the information presented in Bloomberg and the Wall Street Journal. Chris Matthews, among others writing in the journal, said that Morgan had targeted these sons and daughters. Morgan, in the Chris Matthews piece that he wrote along with Emily Glazer and Aruna Viswanathan, entitled JPMorgan Chase Nearing Settlement with Prosecutors on Asian Hiring Probes, said that Morgan was not disputing that employees of state-owned enterprises were covered by the FCPA, because I think that is now pretty clearly established law, particularly after the Eskenazi decision in the 11th Circuit. But the question of whether or not it was a corrupt act to hire a son and daughter or a family member when a country's culture really not only celebrated the hiring of sons and daughters of high government officials, but really expected that going forward. So if there wasn't an explicit quid pro quo, should Morgan be fined and penalized for that? So Professor Stevenson's response, I thought, was very illuminating, because he, with his three-part questions, or three key considerations, I should say, really provided to me and the compliance profession a way to think through the hiring of a foreign government official. So I took Professor Stevenson's formulation and tried to rephrase it in more of a business context. So I phrased it as, number one, does the candidate meet your firm's hiring criteria? Number two, did the foreign official whose family member you're considering for hire demand or even suggest the company hire the candidate? And number three, has the foreign official made or will make a decision that will benefit your company? And if you look at point number one, I think every FCPA analysis starts with this question: is there a business justification? Is there a business justification for hiring a particular candidate? And what is that business justification? Articulate that business justification. If the business justification is this candidate meets our academic requirements, this candidate meets our professional expertise requirements, if this candidate meets our diversity requirements, if this candidate meets our geographic outreach requirements, there's a wide variety of business justifications. But if the only business justification that can be articulated is this candidate will help provide influence or repay a foreign government official or official of a state-owned enterprise who sent us business, that's where I think companies get into trouble. So there have been two previous FCPA enforcement actions where companies got into trouble for hiring of government officials or officials of state-owned enterprises. The first, of course, was Bank of New York Mellon. And in that case, we had officials of state-owned enterprises of an unnamed Middle Eastern sovereign wealth fund, and three candidates, two sons and a nephew, were hired by the Bank of New York Mellon. So we had all three of the prongs met because the first one was the candidates did not meet Bank of New York Mellon's hiring requirements. Not only did they not meet the educational requirements, they did not meet the professional background requirements, but more importantly, they didn't go through the normal hiring process. So there were not interviews, the types of interviews that Mellon normally engaged in. It was not the rigor around background checks. There were benefits given to these candidates above and beyond what normal internships at Mellon were provided. This included payment of visas for travel to the United States. It included additional compensation and length of internship beyond what the normal Mellon internship provided. So pretty clearly, point one was not met. Number two was did the foreign official suggest or demand the company hire the candidates? Well, in the Bank of New York Mellon case, the answer was a very affirmative yes, that the official did. Both officials requested that Bank of New York Mellon hire the sons and nephews. And then number three, would the foreign official make or will make a decision that would benefit the company? Well, foreign officials certainly had made decisions which benefited Mellon, and they pretty clearly, as spelled out in the SEC cease and desist order, indicated that the continued use of New York Mellon would be contingent upon the use or hiring, rather, of the sons and nephews. So in the Mellon case, I think all three prongs were met. Second, we had the Qualcomm case. And Qualcomm involved officials, Chinese government officials. It also involved officials from state-owned enterprises in China. The Chinese officials were those who could grant licenses for Qualcomm to do business in China, and the state-owned enterprises were telecom officials who could direct business to Qualcomm. So looking at the three-part analysis, so once again, under Professor Stevenson's analysis, the questions were the degree of connection between the job offer and a particular official decision or set of decisions as distinct from goodwill and connections. Number two, the degree to which the official indicated that he very much hoped the firm would hire the relative, even if there's not enough evidence of an agreement to establish a quid pro quo. And number three, the degree to which the firm relaxed its ordinary hiring standards to hire the official. So in the Qualcomm case, or looking at it under these three, so under the business justification, unfortunately for Qualcomm, it was both Chinese government officials and the state officials of state-owned enterprises directed the company to hire. It was a son and a daughter, and Qualcomm's employees understood that the parents were responsible for new business development, for business development that had occurred, and allowing the Chinese telecom company to adopt Qualcomm technology. The internship would be an important support for cooperation with the Qualcomm Chinese subsidiary, and the internship would be good because the company was doing a lot of business with the Chinese government and state-owned enterprises. So in terms of prongs 2 and 3, we clearly had those met in the Qualcomm case. Turning to prong 1, the first is that even within Qualcomm, these individuals were identified with the monikers either must place or special hires. So when you have that kind of strict scrutiny, if I could borrow a phrase from constitutional law, or additional scrutiny perhaps more appropriately, I think that is going to be a red flag that unless the scrutiny is of an appropriate nature to manage the risk and not to identify sons and daughters or family members that would violate the FCPA, that's a consideration in and of itself. But the SEC cease and desist order also pointed out that the candidates did not meet the hiring requirements of Qualcomm. So in one case, a candidate, the language was fairly striking, and the order revealed, the SEC order rather, revealed after the initial employment interview, one candidate was rated as a, quote, no hire, end quote, because not only was he not a skill match for the company, but, quote, he did not even meet minimum requirements for moving forward with the offer. There was a second interview of the same individual, and it was said after this interview was written in the employment review notes, there was an agreement that he would be a drain, not even neutral, on the team he would join. So pretty clearly the candidate did not meet the firm's hiring criteria. And thinking again to the business justification, if someone is such a poor candidate that they can't even tread water or even remain in neutral, but actually be a drag on your commercial operations, I would suggest that's a pretty serious indication that they did not meet the hiring requirements. So the next we had whether or not the foreign official asked or demanded that the company hire the son or daughter. And in both cases, we had additional information presented in the SEC cease and desist order that the Chinese official had sought that. And then, of course, number 3, has the foreign official made or will make a decision that will benefit your company? And the cease and desist order had evidence of that in the facts as well. Unfortunately for Qualcomm, there was an additional, as there was with Bank of New York Mellon, there was an additional information that indicated that the candidates or the sons and daughters receive additional remuneration and consideration, which could be certainly part of an overall bribery scheme or plan. So it was noted that as for the official at state-owned enterprise number 1, his son received a $75,000 loan to move to the United States and review his visa. Permanent employment with Qualcomm after the internship program, even though he did not meet the company's hiring standard. Business trip followed by leave to visit his parents back in China, even though other employees were expressing concerns about his qualifications. And so clearly benefits were given to a son under the Qualcomm hiring program. These two enforcement actions were very instructive and gave us a lot of information, but I have to go back to Professor Stevenson for his articulating this really 3-part analysis that everyone should use. If we think about the JPMorgan case, I would say it's going to appear that, at least from what's been presented factually to date, it would appear that all 3 of the considerations were met. Although we don't have information about the number 2, Stevenson's point number 2, the degree to which the official indicated they very much hoped the firm would hire the relative. Clearly, with the spreadsheet that's been referenced in both the Bloomberg and Wall Street Journal articles, we have a tying of the degree of connection, as Professor Stevenson would say, between the job and a particular official decision. And that perhaps is the most damning evidence or the most troubling for JPMorgan. What we don't know at this point is whether or not the candidates met the firm's hiring criteria. If a candidate meets your hiring criteria, that's certainly one factor, and it's an important factor. But if they don't meet your hiring criteria, I would suggest to you that at that point it's really full stop. You can't hire someone who does not meet your hiring criteria absent a business justification. And frankly, I can't think of a business justification to hire someone who doesn't meet your hiring criteria. That's going to work in the FCPA context when you're hiring the son or daughter or a family member of a foreign government official. But how can you use this information in your compliance program? what I've given you with my 3 questions, I think, is a way to take a look at any questions or potential hires that might come through you. So what are some of the things that you can do under the FCPA? Well, I think Professor Stevenson is spot on when he says that you can distinguish the hiring of a well-qualified candidate whose personal family connections might have been a plus factor from the hiring of a lazy and incompetent relative whose only benefit to the firm is favorable treatment by that powerful relative. Clearly, that's a plus, but you need to take your risk management of this situation, because it is a high-risk situation, a step further. Such things as whether or not the son or daughter would be firewalled from working on contracts where their relative held sway over it, either in terms of awarding a contract, renewing a contract, or managing that contract with your company. I think you need to firewall an employee from that type of situation. You couldn't have the situation where the employee was working directly with their family member in some way for your company. So there's management techniques, risk management tools that you can use. And I don't mean to suggest that no son or daughter or family member of a foreign government official can ever be hired, but you need to start out with this 3-part analysis. And really, if they don't meet your hiring criteria, I think at that point you really have to put a full stop on it. But if you do hire them, you have to manage that relationship. And if you think about this in the context of really any other FCPA high-risk proposition, if it's high risk, it doesn't mean you can't do it. It simply means that you have to have a greater level of risk management and risk management around the situation. The hiring of a son or daughter or family member of a foreign official or official of a state-owned enterprise is certainly high risk, and you can do it. But you've got to look at these 3 questions, and you've got to document what your steps you've taken. It really doesn't matter to the government if after the fact you think you can prove that you've met all 3 of these steps, if that was not a part of your decision-making calculus when you were considering whether or not to hire the person. Because if you don't go through this analysis and you don't document your steps, the government's going to assume there was no process. So this can be done. I think it can be done fruitfully. It can be done in a manner that benefits both you and the potential hire. But once again, it's just a high-risk proposition, and if it's high risk, you have to manage that risk more closely. This is Tom Fox. I'd like to thank you very much for listening to this episode. Hello, everyone. This is Tom Fox again. I have 2 calls to action for you, if I could make these requests from you. First is if you are listening to this podcast on iTunes, if you would rate this podcast, it would greatly help us with our ratings. The second thing is that I'm developing my next mailbag episode. So if you have any questions, please shoot me an email at tfox@tfoxlaw.com. This is Tom Fox. Thanks again for listening. I look forward to visiting with you again on the FCPA Compliance Report.